As groups such as the African Americans and the women's rights activists were fighting for civil rights, other groups were pursuing similar goals. Using the Equal Protection Clause of the 14th Amendment, these groups have filed cases which have reached the Supreme Court to expand their civil rights. They include immigrants, people with disabilities, elders, and homosexuals. Throughout history, the interpretation of the 14th Amendment has expanded, as well as the rights of many of these groups. Let's see how incorporation has grown as civil rights have become universalized. U.S. v. Wong Kim Ok. The Chinese Exclusion Act of 1882 was a critical restriction on Chinese immigrants, blocking them from entering the country and denying citizenship to those who were born in the U.S. Wong Kim Ok was born in San Francisco, but because he was born to Chinese immigrants, he was not granted citizenship. After coming back from a trip abroad, he was denied entry into the country because he was not viewed as an American citizen. He sued, claiming that his 14th Amendment rights had been violated, and he qualified for citizenship. The Supreme Court agreed with this argument. According to the 14th Amendment, it states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The justices agreed that the government could not deny citizenship to anyone born in the country. Granting automatic citizenship to people born in the U.S. has led to a great debate, but has been upheld to this day. This concept is known as jus soli, and is the reason why people are called natural-born citizens. Graham B. Richardson. In Arizona, welfare benefits were only given to citizens or immigrants who had residency in the state for 15 years. This included resident aliens or legal immigrants who lived in the state. Graham was a resident alien, so when she applied for welfare benefits after becoming completely disabled, she was turned away. She sued, hoping to receive some compensation. The Supreme Court ruled unanimously that this law was unconstitutional. The justices determined that alienage was a suspect classification, therefore calling for strict scrutiny. This law violated the 14th Amendment's Equal Protection Clause because the aliens were denied benefits that their taxes helped pay for. This case started a trend of the Supreme Court striking down laws that restricted the rights of immigrants, and later, the Immigration Reform and Immigrant Responsibility Act of 1996 was created to set eligibility standards for immigrants to receive welfare benefits. Today, the issue of whether or not immigrants should receive welfare is still highly debated. Many immigrants have turned to welfare programs to get through hard times. Lai V. Nicole. Chinese American students in California were struggling with English because it's not their first language. This caused them to have a hard time in school, who did not provide classes to help them. These families sued the school, saying that the Title VI of the Civil Rights Act of 1964 was violated because they stated that students could not be discriminated against on account of their national origin. They argued that being denied English classes did not allow the Chinese American students to have equal opportunities, which is discrimination. Schools countered by saying that everyone had their own advantages and disadvantages, so schools did not take responsibility in teaching the students English. The Supreme Court ruled that because English is a basic part of education, schools needed to help their students gain proficiency. After this case, the Equal Education Opportunity Act of 1974 would require schools to take actions to ensure equal education for all students. To enforce this, the Department of Health, Education and Welfare set guidelines to keep schools in check, using the school's federal aid as a motive to follow the statutes. As a result of this case, bilingual education has improved, and language minorities have benefited. Port v. Commonwealth of Pennsylvania. A Pennsylvania state law stated that children had to have reached an intellectual age of 5 by the time they reached first grade to be eligible for public education. This meant that mentally retarded children were denied a public education, causing parents to be forced to find other ways to educate them. The parents brought a lawsuit on the state, stating that retarded children had a right to an education, just like all the other kids. The court sided with the parents, deciding that the state law violated the Equal Protection Clause and the Due Process Clause of the 14th Amendment. This forces schools to provide an education to the mentally disabled children, resulting in a law now known as the Individuals with Disabilities Education Act, which requires schools to ensure specialized services for the disabled, including early intervention and special education.
In 1998, Sydney Abbott, a victim of HIV, went to the dentist to get a cavity filled. This happened after the AIDS epidemic, so people were still wary and uneducated about the subject. So, after disclosing to the dentist that she was HIV positive, she was refused treatment unless she paid extra to have it done in a hospital. She sued, claiming the dentist violated the Americans with Disabilities Act of 1990, which prohibits discrimination against individuals because of their disability. The court ruled that the dentist did in fact violate the act, and that physicians were not allowed to refuse or alter the treatment of HIV-positive patients unless the physician felt that there was a direct threat of infection. This ruling gave more strength to the Americans with Disabilities Act and brought HIV-positive patients closer to equality. The elderly. First, we'll start off with the Equal Employment Opportunity Commission versus Wyoming. A supervisor for the Wyoming Game and Fish Department was involuntarily retired at age 55 and filed a suit with the help of the Equal Employment Opportunity Commission, or EEOC, to challenge the constitutionality of such an action. He believed that it was a violation of the Age Discrimination in Employment Act, or ADEA. The court previously ruled on the constitutionality of the ADEA, having decided that it was an acceptable extension of the 14th Amendment's Equal Protection Clause, but it had yet to rule on if it applied to state and local governments as well. The court ruled that this forced retirement was in fact age discrimination and prohibited under the ADEA. Furthermore, it decided that the ADEA did apply to the state and local governments. This prevented future layoffs of local and state employees because of their age, and furthered the policy goals of the EEOC. Meacham versus Knowles Atomic Power Laboratory. In 1983, the Knowles Atomic Power Laboratory decided to do a round of layoffs. They ranked employees by a variety of factors, one of which was age. Of the 31 employees let go, all but one were over 40. 26 of these ex-employees sued the company for age discrimination under the Age Discrimination in Employment Act, or ADEA. The court agreed with the employees. The significance of this case is that the court declared that it was the employer, not the employee, who has to prove that an employee was fired for reasons other than age. This overturned Smith v. City of Jackson, which placed the burden on the employee.
Bowers v. Hardwick. Hardwick was seen at his house, engaging in consensual homosexual activity by a police officer. He was arrested because state law legalized such behavior. The case was brought to the Supreme Court concerning the question of whether or not sodomy was a right protected by the Constitution and if the state had the authority to regulate it. The court ruled that sodomy did not qualify under the right of privacy or as a fundamental right and was therefore not protected by the Constitution. This meant that states were free to create laws concerning it. State anti-sodomy laws were upheld. At the time, there were 13 states that held such regulations. Later, the decision of the case would be overturned in Lawrence v. Texas.
On a weapons raid, police entered John Lawrence's residence without his knowledge and witnessed a consensual sexual act between him and another man, similar to Bowers v. Hardwick. The men were convicted under Texas's Homosexual Act. In this court decision, however, the Supreme Court ruled that anti-sodomy laws were unconstitutional. They violated the Equal Protection Clause of the 14th Amendment and citizens' fundamental rights to liberty and privacy. Texas and other states that had such statutes were forced to get rid of them, and it was a step forward on the path to gay marriage. After years of debate and state-level decisions, the court finally decided to rule on the constitutionality of gay marriage a couple months ago. In this case, groups of same-sex couples in Ohio, Michigan, Kentucky, and Tennessee sued their respective state agencies in a joint effort to challenge the constitutionality of their state's prohibition of and refusal to recognize same-sex marriage. The Supreme Court ruled that the states were violating the Equal Protection Clause and Due Process Clause of the 14th Amendment and that prohibiting same-sex marriage is unconstitutional. This has resulted in further cases that clear problems that arise in the implementation of the decision, such as Miller v. Davis, in which a court clerk refused to issue same-sex marriage licenses, claiming it infringed upon her religious freedoms. She was denied this claim, and her case did not reach the Supreme Court.